Good evening, everybody. My name's Arthur Denton, and I'm a Chartered Legal Executive. I work for Cornish Mutual as the Claims Team Leader. This webinar is going to cover the subject of public rights of way, what the Countryside and Public Rights of Way Act 2006 says, what the expectation for landowners is, and what you can do to protect yourselves and your businesses from claims from the general public, your employees, or prosecution from the Health and Safety Executive. I must take this opportunity to advise you all that whilst I am legally qualified, Cornish Mutual are an insurance company. Therefore, anything that is presented to you is for reference purposes only and should not be considered to be legal advice. It's impossible to offer any specific advice to all of you, as your farms will all be different. For those of you watching this and are members of Cornish Mutual, then any farm policy that you have beginning with the letters FP has a built-in legal expense insurance product, and you have access to a legal helpline and a document portal that can help you with any issues that you may come across. Before I get on to public rights of way themselves, I must tell you that there are two other pieces of legislation that are relevant to landowners. The first is the Occupiers Liability Act 1930. This act applies to anyone that has been invited onto your land. The obligation placed on anyone occupying a property is that the property is reasonably safe for the purposes of use for which an individual has been invited or permitted to be there. This will include the postman, the police, and any emergency services. The act applies to anyone occupying or having control over any fixed or movable structure, including any vessel, vehicle, or aircraft, or a person occupying or having control over any premises or structure. And there have been cases where mobile libraries and aircraft have been considered land for the purposes of this legislation. The second piece of legislation is the Occupiers Liability Act 1984. This act applies to anyone that is not invited onto your land, i.e. a trespasser. The act says that an occupier of premises owes a duty to another not being his visitor in respect of any such risk as is referred to in subsection 1, if he is aware of the danger or has reasonable grounds to believe that it exists, he knows or has reasonable grounds to believe that the other is in the vicinity of the danger concerned, or that he may come into the vicinity of the danger, in either case whether the other has lawful authority for being in that vicinity or not, and the risk is one which in all of the circumstances of the case, he may reasonably be expected to offer the other some protection. This means that you cannot dig trenches or set traps to deter people from entering your land, as if they are injured, you are likely to be liable. There are 4 categories of rights of way. Public footpaths, where the public have a legally protected right to travel on foot. Any walker with a dog must have a dog under close control. There is no requirement to have a dog on a lead. There is usually no right to cycle or ride a horse on a public footpath. Public bridleways, the public have the right to travel on foot or to travel on horseback or leading a horse. Cyclists are also permitted to use a bridleway, but must give way to others used on foot or horseback. Restricted byways, the public's right to travel on a restricted byway is limited to on foot, on horseback, or leading a horse, or by any vehicle other than mechanically propelled vehicles. So that would be bicycles or horse-drawn carriages. And then there are byways open to all traffic. A byway open to all traffic, or a boat, is a highway over which the general public have a right to travel for vehicular and all other kinds of traffic, but which is used by the public mainly as footpaths and bridleways. As a landowner, you are not allowed to block access or restrict access to these rights of way in any way. There are also permissive footpaths. A permissive path, permitted path, or concessionary path is a path which could be for walkers, riders, cyclists, or any combination of those, whose use is allowed by the landowner. A permissive path is often closed for one day a year, historically Christmas Day, which then breaks the continuous use which is required for a permissive path to become a statutory right of way, and that would be a continuous use for a period of 20 years. Usually, I would encourage anyone with a permissive path to take a photograph of the locked gate with a time and date stamp on the photo to prove that the path has been closed. Whilst the public have a right to travel on any public right of way under the Countryside and Right of Way Act 2000, they may only do so if he does so without breaking or damaging any wall, fence, hedge, stile, or gate, and he observes the general restrictions in Schedule 2 and any other restrictions imposed in relation to the land under Chapter 2. The restrictions in Schedule 2 are things such as has with him any animal other than a dog, unless on a bridleway, feeds any livestock, or uses or has with him any metal detector. Right of way do not fall under either of the Occupiers Liability Acts that I've mentioned. If you have any rights of way through your property or land, then the common law applies. That is, that you must take all reasonable steps to maintain that right of way so that it is reasonably safe for users, as any injury or damage that is reasonably foreseeable will be the liability of the landowner. You may not, for example, place a bull of over 10 months of a recognised dairy breed. That would be Ayrshire, British Friesian, British Holstein, Dairy Shorthorn, Guernsey, Jersey, and Kerry in a field that is crossed by a public right of way. Those breeds of bull are banned. Any other breed of bull over 10 months must be accompanied by cows or heifers. If you have an animal where a cow, heifer, or a bull that you know could cause harm to a person, and it actually happens, then you could be liable for prosecution by the Health and Safety Executive. In 2003, we've seen a case in Wiltshire where a farmer based near Bradford-on-Avon was fined after 2 members of the public were attacked and injured, one fatally, by cows in a field. Swindon Crown Court heard how brothers Mike and John Porter were walking on a public footpath which went through a field where cows with calves were grazing. The cows belonged to local farmer Brian Godwin. The brothers had with them 2 dogs on leads when they were attacked by the cows. The incident was the 4th in 5 years, involving injuries to members of the public caused by Mr. Godwin's cattle. Mike Porter suffered fatal internal bleeding from crush injuries caused by cattle trampling him. His elder brother John Porter suffered multiple rib fractures, a punctured lung, and general contusions, but survived. The cattle may have attacked the walkers because they perceived a risk to their calves from the men and their dogs. An investigation by the Health and Safety Executive into the incident, which occurred on the 13th of May 2013, found the farmer had not taken reasonable precautions to protect members of the public walking on footpaths through his fields from his cattle. Where livestock are judged to present a risk to walkers, they should be segregated by fencing or kept in fields without footpaths. Mr. Godwin pleaded guilty and he was given a 12-month prison sentence, suspended for 2 years, and ordered to pay costs of £30,000. This is an extreme example of the position that you could find yourself in, but is a clear indication of the Health and Safety Executive's view of such incidents. And if you do have an incident similar to this, they will investigate thoroughly to ensure that you did not knowingly place an animal that you knew to be a danger on land where the public were likely to be. The best advice is that you, wherever possible, should avoid keeping cows with calves in fields with public footpaths. If that is impossible, you need to keep cattle and walkers apart, either by temporary or permanent fencing. This is even more of a possibility now more and more people are accessing the countryside. As well as ensuring that you do not endanger anyone on your land with your animals, it is also the duty of the landowner to make sure that things like stiles are kept in good repair and that there are no hazards on the path. Note, though, that if a person steps off of the right-of-way or off of the path, then they become a trespasser, unless the path is blocked, and then a walker is permitted to step off the path and around the hazard, but must return to the path as soon as reasonably practicable. Under Section 14 of the Countryside and Rights of Way Act, it is an offence to display on access land notices deterring public use. You cannot use words such as "your dog must be kept on a lead," because this is not correct. A dog only needs to be under close control, or "danger bull," because this will clearly deter anyone wanting to access the field. On the screen now is the wording from the Act. It says this section has no associated explanatory notes. If any person places or maintains A, on or near any access land, or B, on or near a way leading to any access land, a notice containing any false or misleading information likely to deter the public from exercising the right conferred by Section 2(1), he is liable on summary conviction to a fine not exceeding level 1 on the standard scale. So that would be a fine of up to £200. The court before whom a person is convicted of an offence under subsection 1 may, in addition or in substitution for the imposition of a fine, order him to remove the notice in respect of which he is convicted within such period, not being less than 4 days, as may be specified in the order. A person who fails to comply with an order under subsection 2 is guilty of further offence and is liable on summary conviction to a fine not exceeding level 3 on the standard scale, and that would be a fine of £1,000. So you will see that if you ignore the initial advice to remove a sign by the local authority, then you could face additional fines. The wording that you use must be clear and factual, and I would suggest short, as no one is likely to spend a long time reading a sign. "You must keep your dog on a lead" is not permitted, as this could suggest to someone that they are not allowed to enter the field without their dog on a lead. This, of course, is not correct, as the dog only has to be under close control, and there is no definition of close control. The following signs were all taken from the Lost Gardens of Heligan and are a good example of what you can and should say. The first highlights stumbling hazards and overhanging branches. The second, slipping and stumbling hazards, steep gradients. The one on the left, "don't climb the wall," and then "don't walk on the flower beds." It's slightly different for Heligan, as the paths are not rights of way, and the people visiting are fee-paying guests, and so the Occupiers Liability Act 1930 will apply. But they are a good example of what you should be considering when you are placing signs. What are the hazards that you should be warning people of? And finally, this sign speaks for itself, as it's erected on public access land, which your rights of way would be classed as. It's a good idea where you have lots of open fields and paths running through to have way markers or some way of a walker easily identifying the right of way. Because as I mentioned before, the walkers are only entitled to be on the path and not anywhere else on the land. Thank you for listening.